Welcome to Free Law School. Is the audio good, Jason? Welcome to Free Law School. My name is Gregory Swafford. We're talking about business structure. What is business structure? Does your LLC provide you with the level of limited liability protection that you signed up for? That's the question. Does your LLC or corporation provide you with the level of limited liability protection that you signed up for? How do you even know? How do you know? Here's another question. Is your name on your business? Or are you totally separate from the business? We're going to get into that. We're going to answer those questions. One of the things that we've been talking about over the past several conversations is that most businesses are built backwards. Most businesses are built backwards. Now, you might ask, how does that happen? Well, if you formed an LLC or a corporation without giving any consideration as to whether or not your assets and risk should be separated, then you built the business backwards. If all you have is the single entity, operating entity, that LLC or corporation, then you do not have protection. You're exposed, your assets are exposed. And, you know, for the business owner, the entrepreneur, you've been conditioned to believe over time that all you need to do is form an LLC or a corporation, and that's it. You're protected. Nothing could be further from the truth. That's not protection. Those are just the containers that are used in order to operate from. The protection comes later. Now, let me say this from the beginning. This conversation is not about credit funding. It's not about how you get a grant business structure in order to secure grants. That's not business structure. And I think that that's a big part of the confusion because there are many people online selling the idea that business structure encompasses all of those things: grant funding, credit funding. If you have an LLC or a corporation and an EIN number, you can get a stack of credit cards. Those things are not business structure. Business structure is about what happens when something goes wrong. We're primarily talking about limited liability protection. Yes, when you're considering whether to form a corporation or LLC, there are tax considerations. Those are major considerations. But for the purpose of this conversation, we're talking about limited liability protection. What happens to the business under pressure? And even more specifically, the question is whether your business operates independently of you or whether that business is dependent upon you. And your business sends out signals every single transaction. Once you decided whether or not you was going to form the LLC or a corporation, and you began to enter into business transactions and activity, the business begins sending out signals. And those signals are picked up by a number of institutions. Yes, there are any number of institutions that picking up that information on a daily basis as it happens. It's being stored, that historical record. And it's incumbent upon the business owner to document the historical record. The institutions are banks, courts, insurance underwriters, regulators, investors. They all have their own rules on how they operate, but they share one thing in common. Does this business operate independently of the owner? Banks want to know when you apply for a loan whether the determination as to whether or not the business operates independently can make the difference in whether or not the bank asks for or requests a loan guarantee, or whether the interest rate is higher, or whether credit is even extended. The insurance underwriters, they're looking at the same information, whether or not there is exposure on the personal side, and the exposure on the business side that could actually collide and create a greater exposure. In that instance, premiums are going to be higher. They're using that information to determine what the premiums are. Those signals are being sent out as we begin to do business. Now, here's what most business owners believe and have been taught. that once you form the LLC or the corporation, you're protected. That formation provides a protection, and that those documents that we receive are proof of that protection. That is not the case. Forming a business entity does not provide protection, nor does the documents provide protection. The protection begins after the formation. Each transaction entered into is creating a record, sending out a signal as to whether or not the business is personal or whether it's separate from the owner. If it's personal, that means that the owner acts on behalf of the business. The business does not act on its own independently. And that's what all of the institutions are trying to determine, whether the business is separate. Now, when we go out and we form the LLC or the corporation and we begin doing business, most business owners do not unplug their personal financials from that scenario. And here's what I mean by that. Imagine that you have a power strip, a single power strip, and your entire financial life is plugged into the power strip. Bank accounts, your home, your salary, contracts, and the LLC. Everything plugged into that single power strip. Now, imagine that a surge occurs. When the surge occurs, everything is going to be exposed. Your entire financial life is exposed. And that's how many business owners operate. They form the entity, but they never unplug the personal items. Everything stays in that one personal power strip. Now, to the business owner, it feels like they did it right. They formed the entity. But the institutions, when it's time to review, all they see is the person still with a different name, the business name, but everything else remained the same. Now, I asked a moment ago about business owners who have been operating for a while. If you've been operating for a while, I want you to reflect on this for a moment. Prior to operating prior to forming your business entity or at the time of formation, did you give any thought as to whether or not your assets and risk should be separated? We all know what the assets are. We just talked about them. They're all there, plugged into the single power strip. All of the assets are there. Now, here's where the risk is. The risk is there on a daily basis inside the operating company. That's that LLC or corporation that we do business out of every single day. That's where the risk is. Public facing entity. You engage with customers there, vendors, employees, all of your public facing activity is right there in that operating entity. If anything is going to go wrong, it goes wrong there. Now, imagine all of your valuable assets there, entwined, entangled with the potential risk. Now, what do you think happens if the business activity causes harm or injury? Now, for you guys who are just joining, we're talking about the fact that most businesses are built backwards. And if your assets and risk are in the same place, then the entire purpose behind forming the LLC or the corporation has been defeated from day one. Because remember, the purpose behind forming the LLC and or the corporation is to separate your personal assets from any business liabilities. That means if something goes wrong, your home, your vehicles, your bank account, retirement account, whatever you own of value is protected from seizure and sale to satisfy that judgment. That's the entire purpose. Now, many business owners are mistaken, misguided about the entire purpose behind forming the business entity. There's a misconception that formation is done for the purpose of opening a business or starting a business. That's not it. This is about protection. Because when we're talking about business formations, you can do business without even forming a business entity. That's the sole proprietorship. People do it all day, every day, misguided as it may be. It's done. What that means is that the business owner, the person engaged in the activity, there is no separation, there is no shield between that person and the business activity. If anything happens, if the activity causes harm or injury, boom, the business owner is responsible. The liability will be placed there. Personal assets exposed. That's why we formed the business, to avoid that scenario. Many business owners default to the LLC. It's the workhorse. It's easier to maintain. It's used worldwide. Not the LLC, the limited. We call it the LLC here. But there's a form of the limited company that's used globally. Because of the ease of use. That's why the corporation is a little more rigid. There are formalities to follow in order to maintain the limited liability protection. If you violate, if you're not in compliance and you form the corporation, then that's a pretty clear and direct route to disregarding the corporate entity. You may know the phrase, pierce the corporate veil, piercing the corporate veil, or the business owner was considered or determined to be the alter ego of the company. That means that there is no difference, there is no distinction between the business owner and the business. It's all one and it's all personal. There is no shield in that instance. So, again, most business owners default to the LLC We form it, begin operating, thinking that there is protection. There's no protection there. There is exposure. Business structure is layered, and the layering exists in the following manner. Ownership should be separate from control and assets. Remember that question? Are your assets and risk located in the same place, in the same entity? Ownership, control, and operations. What are we talking about? We're talking about the trust, that's the ownership level. The holding company, that's the control level and the asset level. And operations, that's the management level. That's what the layered structure looks like. And when the structure is operated and installed properly, all of those things are separated and they come together in conjunction with the insurance to provide protection. That's what it looks like. But again, many business owners are operating with what I refer to as the single entity trap. Yes, it's a trap. That's where you operate out of that LLC or corporation. All of the assets are there. And there's a scenario that's even more convoluted than having assets and risk in the single entity. And that's where many business owners are operating the business with assets titled in their personal names. Real estate investors, landlords, properties titled in their personal names, leased out to tenants, business owners, maybe owning the brick and mortar from which they operate in their personal names, but used in the business. How do you explain that? That's how do we make an argument that there is separation between the business owner and the business when in actuality, the business owner is using personal assets to operate the business? That places those assets at risk as well as the business assets. Because now we have the potential of a collision between your personal and your business life. That's called inside liability and outside liability. It's not, most business owners are not even aware of the possibility that their personal lives and their business lives can collide, placing placing business assets at risk because of personal liability, outside liability, and vice versa, placing personal assets at risk because of inside liability, business problems. Inside liability refers to the things that happen inside the business. Let's say a breach of contract claim, con- um, employee dispute, creditor default, those are inside liability claims, things that happen as a result of business activity. Outside liability claims are the things that happen in our personal lives. It could be divorce proceedings. Maybe there was a default on a personal debt. Maybe you co-signed for a family member or acquaintance. They defaulted on the debt. Judgment was not only taken against them, but you as well. And those judgments are just out there. The judgment holder, though, has the option of asking the court for a charging order in order to collect on that judgment. And here's what makes that possible: it is possible where the business owner's name is on the business, where the business is not separate from the owner. If the judgment holder can demonstrate that the business is not separate from the owner, then if the court agrees, they can force the business owner to turn over the distributions from the business in order to satisfy the personal judgment, the judgment that had nothing to do with the business. The distribution, that's the profit. That's your profit. They can force you to turn over the profits from the business that had nothing to do with that judgment that was rendered, merely because there is no separation between you and the business. Therefore, they can get it from wherever they find it. That's the idea. That's how your personal life can collide with your business life if you are not structured properly. Now, here's the converse of that. Here's the other side where your personal assets are exposed because of business activity. Creditor claims, breach of contract claims, employee disputes. If your name is on the business and a judgment is rendered against the business, then the judgment holder can seek to execute, collect the judgment amount from wherever they find it. And because your name is on the business, you didn't structure properly from the beginning, they can seek to satisfy it from personal assets as well. In the event that the business assets are not sufficient to satisfy the judgment, well, here comes the personal part. So structure matters. It's about what happens when things go wrong. I know that there's a lot of hype on social media about let me provide you with a package to structure your business so that you are attractive for grants or attractive for a stack of credit cards. All of that stuff is misinformation. It's not structure. Those are tactics, financial tactics. They're not bad in and of themselves, but they're not structure. Structure comes first. If your container is leaking, placing more items or assets inside the container doesn't help. It doesn't plug the leak. Everything is still going to come out, creating greater exposure. because we still have to account for all of those things. They're not free. So structure comes first. That's what happens. We've been having these conversations with pro sepreneurs. I coined the term pro sepreneur. Look, I represented business owners for over 30 years as an attorney, as well as having made throughout the course of my career my own fair share of missteps. So I understand. And I've also witnessed business owners find themselves in those pressure events, particularly litigation events, where they only find out that they're exposed, that they had no structure at the end of the litigation when it's time to pay up or lose assets. That's when you find out. And that's primarily because business structure is only tested under pressure. It's not tested when things are fine. You can grow the business, scale the business, revenue is growing year over year. If there are no pressure events, the business owner never realizes that there is no structure, particularly if all you did was form that single entity and everything is sitting there. The structure doesn't get tested during calm periods. It's only tested during those pressure events. Again, the pressure events could be any number of things. It depends on what institution is looking. Banks, courts, creditors, underwriters, investors. It just depends. Whether you were applying for a loan or whether you were defending against a claim or seeking additional coverage in your insurance policy or taking on an investor, everybody's trying to get to the same answer. Does the business operate independently of the owner? And now, the institutions, they understand that there's no such thing as perfection. When we form the entity, some of you guys may have had your entity formed for you through one of the commercial outfits, and they provided you with an operating agreement. If you formed the LLC, you were provided with an operating agreement. The operating agreement that acts as the internal rule book for the business, how it's going to operate. It's the governance document. Now, many times that document is based upon, for many business owners, it's based upon the default rules in the state where you chose to form your business. And that can be problematic. If you're operating with that, I implore you to take a look at your operating agreement and personalize your operating agreement, particularly if you have a multiple member LLC. You want to look at things like valuation and exit planning and all of those things like that. They belong in that agreement. But there are also other operating provisions in that agreement on how the business intends to operate, how the business should operate. If we're talking about a corporation, those are going to be your bylaws. The shareholder agreement that regulates or operates to define the relationships between the shareholders. Again, things like exits, valuations, rights of first refusal, all of those things. Who signs, who applies for loans, all of those things. Now, from the moment that the container is secured, formation, we begin to send out those signals. And the signals are sent out based upon the business activity. Secure the contract. How was that contract signed? Was it signed on behalf of the business, or did we just sign it in our personal capacity? Creating that historical record with those signals. Did we guarantee, personally guarantee a loan? How is the lease signed? All of those things that happen in the operation of the business on a daily basis, those signals are being sent out. And until a pressure event arrives, they're just signals that's just out there. But when the event arrives, and now the business has to provide documentation in order to support a classification of separate, that's where it gets tricky. Because now the institutions, and look, business owners always say, well, I'm not bothered by that. I have my paperwork. I have my paperwork. I was always on time with filling out my annual reports, and I paid my franchise tax or fees on time. I'm good. I'm good on that. But remember this, paperwork is not protection. Paperwork reflects intent. The paperwork only matters to the extent that it aligns with the business behavior. Nobody says in their bylaws or in their operating agreements that they're going to run out and sign on behalf of the business, that they're going to act as a guarantor on behalf of the business. I've never seen that. I've never witnessed that in any company documents. That just happens. Those things are situational occurrences. And yes, situational occurrences, they do happen. And the institutions understand that they happen. They understand that there's no such thing as perfection. So when the event arrives, whether it's the loan application, the investor due diligence, the insurance application, the regulators, maybe let's say IRS audit, they understand. So now what they're doing is they are looking at those signals, the behavior, because the behavior creates patterns. So now the institutions are observing those patterns to determine whether or not they are repetitive. Because when the patterns become repetitive, they become the structure. That's the structure. It's no longer situational. Yeah, sometimes we may have to step up and take cash out of the personal account and inject it into the business. It feels good to be able to do that. The business owner doesn't feel like they're doing anything wrong. In fact, it feels responsible. But when that becomes repetitive behavior, it's viewed as the actual structure of the business. This is how the business operates. So the behavior creates those patterns become repetitive. The institutions take that repetition and uses it to classify the business as personal or separate. And the purpose for the classification is to determine where the liability is going to be placed. If we're talking about courts, if we're talking about banks and financing, whether credit will be extended, whether loan guarantees will be required, if we're talking about insurance, whether the premiums are going to be higher, are there going to be exceptions or exclusions in the policies? The investor wants to know, certainly, does this business operate independently? Who controls the business? Not who owns it, who controls it? So those things matter. And when those signals are interpreted as personal, that's when the paperwork becomes irrelevant. It's not that it's invalid. It's fairly easy to keep the paperwork valid. It becomes irrelevant because remember, the paperwork reflects the intent, how the business intends to operate. When the intent is no longer in alignment with how the business is operating, that is called structural drift. That's the drift. And that's how we get classified as personal. Now, again, I've been having these conversations with business owners, the pro sepreneurs. I represented a lot of business owners over the years, again. And many of those business owners performed a fair amount of activity on their own, but mainly confined to their level of expertise in the business. Many wanted to understand how business structure works and how to maintain, but they were never given any support in understanding that. And that's how I came up with the idea of the pro sepreneur. Some of you may be familiar with the Latin phrase pro se from hearing about persons who represent themselves in court. We're not talking about representing yourself in court. In fact, the word pro se, the phrase pro se is defined as for oneself. For oneself. And you're familiar, you already know what the entrepreneur is. Person who works for his or herself in business. Okay? So the pro sepreneur is a person, a business owner, entrepreneur who is structurally literate, who understands how business structure works, and who refuses to outsource their understanding regarding the environment in which the business operates. It just makes great business sense because, again, business structure is about behavior. So when you outsource it, when you think that you have structured a business by purchasing a commercial outfit to form a LLC or a corporation, all you did was get some paperwork. The structure is going to come from those business activities yet to be made. So, how do you know how to move? That's what structural literacy is all about. Taking responsibility for understanding the environment in which the business operates. And so, for those individuals, I know this conversation may be a little uncomfortable. If you're hearing this for the first time, that your assets and risk being existing in the same entity creates ongoing exposure, that can be a little uncomfortable. But here's the positive side. That's awareness. And if there are no pressure events existing right now, particularly litigation, creditor defaults, lawsuits, demand letters, if you're not involved in any of that type of activity currently, then it's the perfect time to structure your business properly. Perfect time. The best time was in the beginning. But if we miss that opportunity, the next opportunity is now. And here's why that's so important. I hear this all the time. Business owners, when I ask the question or engage in the conversation, they're like, well, when I formed the business, I didn't have any legal problems. And the expenses associated with lawyers and all of this kind of stuff, I preferred to invest my funds, my resources in getting the business up and operating. And it was my full intention to circle back. Many times, the pressure event arrives before the circle back actually happens. And that's really unfortunate because now we've probably 10x'd the cost of dealing with the problem, if not a fatality for the business. If you have yet to form your business, if you're getting ready to launch something, then this was a great conversation for you. And hopefully, you walk away from this conversation understanding that you should think about business structure before any money arrives, as well as before any risk arrives from the beginning. Now, if you're already operating, you can restructure. You don't have to dissolve anything, you don't have to shut anything down. Your structure can be installed without affecting the operations today. It can be. And there's a reason why it is so important to do that prior to the event. Because what we're really talking about, if your assets are in the wrong place, particularly if you're operating with that single entity, what I refer to as the single entity trap, if that's how you're operating, we don't have to do an evaluation. We don't have to do any forensics, any of that. We already know that there is exposure there. There's exposure there. If you're operating and maybe you installed a separation and you've been operating over time, if you're not operating out of the single entity, you have the multiple entities and things are layered, then this conversation is for you as well, because over time, structural drift happens. So there is a need to do an evaluation to determine whether or not the business activity remains in alignment with the documents, with the intent. Now, regardless of whether you're operating out of the single entity trap or whether you have a layered structure but have not reviewed that structure over time, here's why it's important to do so. When the pressure event arrives, you are effectively precluded from moving anything around at that time. If the business owner attempts to restructure assets once a lawsuit or claim is filed, the other side is going to cry foul. And in many instances, the court will unwind that transaction as a fraudulent transaction. Bring it back. And the fraudulent transaction, the court views it that way because they are asserting that the transfer was made in order to prevent the claim holder or judgment holder from being able to access those assets in order to satisfy the judgment. So once the claim arrives, you're kind of locked into a status quo moment. But if we restructure prior to any event occurring and everything is in its right place, the ownership is separate from the control and assets, and that's separate and sits above the operations, then one of the worst thing that could possibly happen if a judgment is rendered against the business is that the business owner will have to reform another entity and continue doing business. In other words, you lose that entity. You dissolve that entity. But the assets that are used in the business on a daily basis, those assets were protected because they were in a separate entity. Only the entity that caused the harm is responsible for that harm. So basically, what we've done, what you've been able to accomplish with the layering is you isolated the liability at the operating level. That's what you did. That's what you accomplished. And when we look at the layered structuring in conjunction with the insurances, that's how the business owner secures the protection. That's the structure when it comes to limiting liability. That's the structure. So, this awareness, it becomes an issue about what do we do with the awareness? Well, if you're operating out of the single entity trap, there's no question that there's exposure there. there is a link in the description that will take you to the other social media handles, the IG, the LinkedIn. Send me a message there. We'll jump on a call. We'll talk about business structure, where you are, and what it will take for you to operate as a pro sepreneur, to get your structure in place, to become structurally literate. If you're already operating the business and you had some form of separation, you're not operating from the single entity trap, then inside the description, there is a tool that I devised called the Structural Exposure Check. Takes about 5 minutes to do. It's going to look at the own separation of ownership, the separation of roles and authority, continuation, assets. It looks at all of those potential points of failure. And you need to answer those questions. It doesn't come to me. We can talk about it later when if you decide to have that conversation about business structure. But you need to answer the questions honestly. And what I mean by honestly, I mean how you're actually operating now. Don't answer them from an aspirational standpoint or how you believe the answer should go. Answer it based upon how you're actually operating. And it's going to give you a risk score. That's in the description. And if you would like to talk after that, again, the link is also in the description to IG and LinkedIn. Look, I appreciate you guys for joining the live tonight and sitting here. I hope that you've been made aware. And again, if it was a little uncomfortable, consider that as just awareness. If there are no pressure events, then let's fix your structure. Thanks again for joining the Prosapreneur Network tonight. This is Gregory Swafford with Free Law School. Have a great evening.